I'm sure there are many questions, and so we're going to have a 10-minute period where you can ask. And so if anybody would like to raise a hand and ask a question.
Thank you. My name is Pat Mkize. Comments. Thank you, Professor. My brother, we met at UNISA.
Hi, Carrie. Hi.
In June.
Yes, thank you.
Thank you. Let me agree. Let me comment in as far as mediate, to punish, or to prevent. I agree with you. I think in 1998, I was mediating after the Truth and Reconciliation Commission had given Captain Mitchell an amnesty. Then I was called upon to mediate his reintegration into the community, Trustfield, next to Durban. When I was there facilitating this kind of communication, the community, which had been aggrieved by Captain Mitchell's deeds, they stopped me during this facilitation for integration. They said, Mr. Mkize, no, this man must be punished for what he did. He must be punished. Then I said, I acknowledged the pain they had suffered. But I said to them, we are here, we are making the past the basis upon which we look at the present so as to attain the future. Hence, I agree with you.
Thank you.
I agree with you.
Thank you. And I think one of the things that we also talk about is, sometimes we tend to mistake accountability with punishment. I think every person that is aggrieved would want the person who is the aggressor to be held accountable. Yes. Not necessarily punished in the sense of being punitive. I think the studies have indicated even crime victims in the worst kinds of crimes you can imagine.
Yes.
A couple of weeks ago, when one of my former students was almost killed about 24 years ago. He took my class on restorative justice. We'll talk about victim offender mediation. So he got inspiration from that experience, doing the role plays, to reach out to the person that tried to kill him, who was his friend, when he was 19 years of age. At the end of the day, he said, him being in prison, and this person may never come out. It's life without parole in somewhere in Southern California. So we had this victim offender dialogue, went with him, with another person to facilitate that process. There were 4 things he really wanted. One, of course, was some questions he had. Every time a crime occurs, there is always that why me? You always have the kinds of questions. How did he get into my house? What did you do with the money? What was your intention? And so on and so forth. He also wanted to know what he was doing to try to make amends. In other words, he wants him to come to a place where he realized that what he did was wrong, so that another person will not be a victim, whether in prison or elsewhere. So we can talk about accountability measures, to hold people accountable for what they have done, not necessarily punish them for the sake of an eye for an eye, if you know what I mean by that.
Yes. The last point, the issue of Ubuntu, African values, is also quite important, as we have emphasized. Let me take you to Kodesa in South Africa when we were negotiating constitutional democracy. There was a stalemate. The IFP, Inkatha Freedom Party, did not want to participate, to be part of that. So they realized, Mandela, de Klerk, and others realized that, hey, we're not going forward. Eventually, they had to invite former US Secretary of State, Dr. Kissinger, and if I'm not mistaken, Mr. Carrigan, something like that. They came to South Africa in order to mediate, to break this deadlock. When Dr. Kissinger and Mr. Carrigan arrived, they did not proceed towards the airport. Why? It's because the ANC and the National Party
Okay.
had not developed an agenda that was clear enough. So because, in my view, they are applying this Western approach, not traditional conflict resolution approach. They said, we're not going to participate here. What did they do? They returned back. Returned back. And then South Africa was teetering on the verge of what? Not war. Of a verge of the IFP not participating. The values of Ubuntu, so critical. An unknown professor, Professor Okomo from Nigeria, he met the IFP leader. Per coincidence, you know how he was able to persuade him to participate in that constitutional making? He said to Chief Buthelezi, my brother, remember when we met during the breakfast some time ago? That emphasis on my brother. Chief Buthelezi saw this guy respecting him, putting him in the position in which he was supposed to be. So what I'm trying to emphasize is the values of Ubuntu. If you are coming with your Western approach, with this alternative dispute resolution issue, you are not going to succeed. So it's critical that we also emphasize on the values of Ubuntu. Thank you.
Thank you very much for your wonderful presentation regarding traditional system of conflict resolution. I just would like to ask, so how is the situation of traditional system regarding documentation? Has that been documented in written form, or is orally just transmitted? And another thing is that how is the situation of traditional system implementation? So has the government, how's the situation of government recognition over the traditional system? Because in Nepal, what we can see is especially indigenous people do have their own traditional system, customary law, but then government are not giving that much recognition over it. So I just would like to know the situation in Africa. Thank you.
Thank you. Good question. It does vary. Some places you'll find good documentations, either by way of some of these cases going up to the court and being litigated at the appellate court level. In the late 90s, the famous case of Otieno in Kenya, for example, two famous Kenyans who, the husband died and the wife, who was also an activist. Otieno was a famous lawyer, died interstate without a will. And they lived in Nairobi. The wife and the children wanted him to be buried in Nairobi. His brothers wanted him buried in the village, in the ancestral home. So eventually the case went all the way to the Kenya Appellate Court, which is at that time, they didn't have a Supreme Court, but it was the same Apex Court. And the Kenyan Appellate Court, Appeals Court at the time, which was the highest court in the land, ruled that he should be buried in his ancestral home in the village. So because they made a distinction between a home and a place. And they say that his home was in the village, and what he had in Nairobi was just a house. Okay? So if you adopt a case study approach, looking at those kinds of decisions, and quite a good number of them in different parts of Africa, you find a good amount of documentation where the oral traditions are being at least brought to life, to some extent. It is also the case in instances to the extent that you're looking at the disputants. One of the things that we have done in our work in Africa on alternative dispute resolution, namely mediation. The parties will come together. It may be a case that is already filed in the court. The court agrees to send it off for mediation. We have the mediation. They have an agreement. In most 90% of the time they do, or more than 90% of the time they do have an agreement. And part of the agreement may mean that they will reduce that into writing. and then bring it to the court, or the magistrate or the judge would sign off on it, and it becomes an order of the court, enforceable in that regard. And we do know that mediated agreements have high rates of compliance. Or sometimes they may agree. They say, no, we don't believe in this writing thing, you know. They may agree to go to the village shrine and take an oath. That oath is as effective as, you know, in some places, if you live within 6 months or 1 year, it means you have survived the oath, right? You know, to some extent. If, God forbid, you die before that time, it means that you are at fault or you have done something wrong. So you have these kinds of documentations, both formal in terms of the institutions or within the customary court processes. In Ghana, for example, you do have a very deliberate effort to codify much of the customary practice and decisions by the chiefs, so that they would have, again, this power of precedence and record as well. So it depends on where you are, but there is some element. We could do more of it for sure.
Yeah, thank you. My name is Dennis Michesha, and I come from Rwanda. In fact, I'm going to attend the conference where he's rushing to. I will also leave on the 1st. My question is about the hybridity you are talking about of traditional ways of dispute resolution, and probably also putting in the modern ways. And when some authors are analyzing traditional ways of conflict resolution, in my view, there is a mistake that is committed, because there is a comparison, maybe on the basis of human rights, and it is considered that some traditional ways of conflict resolution may be judged violating some human rights. Maybe to put into consideration, like presence of lawyers in the traditional ways of conflict resolution. Most of the transitional ways do not fully consider maybe presence of lawyers in resolving disputes. And when someone is dealing with the parties, that would be, I'm talking about that because the professor is also a criminal law professor, or criminal justice. Yes. So what is your view on such a situation where a traditional way or traditional ways are considered to be violating human rights because some modern ways are considered to be the best, while the traditional ways are considered to be violating human rights?
Yeah, it's a good point. I did make one of the key findings or lessons, again, is this issue, especially in the area of gender, women's rights, where the traditional practices or systems may come in conflict with international human rights, for example, provisions and so on and so forth. And of course, there is a reason why that is in place, and that would make sense for every country to live up to its legal obligations. So I'm definitely in favor of that. The question is, how do you try to get that shift to occur? And I'm always a believer in a consensus collaborative approach to problem solving, where you use education, because that is usually a reason why such rights are in place, right? So you adopt an interest-based model to educate the public or the culture in place about the importance of that particular right. Not so much what the right is, but why that right is important. And we face this issue in many instances in different parts of Africa. I remember one particular case where the topic was about inheritance in a mediation type of setting, and the man had taken a stance that according to the culture, the custom, the woman is not supposed to inherit, blah, blah, blah. And she's saying, the law is on my side. The formal law is on my side. Now, knowing fully well that there is no way they're going to get a resolution in the court after about almost 10 years of this case languishing in court, it's like, okay, this is what positions you've taken, how can you then move out? And begin to ask the man, what is the source of this tradition? Okay? And sometimes the typical answer is, that's the way it has been forever. But when you ask, which does not answer the question of why. So when you're able to adopt an interest-based approach to asking the why question in a respectful, engaging, insightful way, you begin to shift their thinking. You say, well, maybe just because it was the way that I understood it doesn't mean it's the right way or the way to go in terms of our present exigencies. And that's the point I make before, that no culture is static. Every culture does change. It's a matter of how that change occurs, how rapid or gradual it occurs, and when do we realize that actually it has changed, in a sense. In the work that we do, in terms of lawyers specifically, in mediation, yes, sometimes we tell our law lawyers if the parties would want that, there is nothing wrong with it, and because lawyers are part of the stakeholders that we're talking about to seek a resolution. And so the question becomes, what would be the rule of engagement when you have lawyers involved or engaged in the mediation process? But also there are some places where we say, no, this is basically between the parties in the presence of a mediator. After, in the United States here, you have a small claims court, for example. One of the rules of a small claims court is that there will be no lawyers, by and large. It will be basically the parties who are involved. So there is nothing necessarily out of place in saying, this is what the rule is, and these are the methods by which, especially if the parties have willingly, knowingly come to an agreement about those rules. Just makes sense. Again, I don't want to suggest that it's going to happen overnight, but it is actually happening in many significant ways. And I know in Rwanda, after the, Gacaca is now the Abunzi, I believe, that is in place. Let me point out a couple of, in reference to the question earlier before about documentation. This is a book that William Zatman edited 1990, 2000. I have a chapter here. Traditional Cures for Modern Conflicts, African Conflict Medicine. You can take a look at it if you can. And this one of our publications that I edited came out early this year. I do have a couple of copies. Peace and Conflict Resolution in Africa, Lessons and Opportunity, a collection of papers from different parts of the continent. And I have a couple of chapters also on traditional methods of conflict resolution, including the SAN in South Africa. And if I may make a plug, before I take off here, I have some brochures of our new Africa Peace Fellows initiative, some brochures, I can't leave them. What we're trying to do is, in a more conscious way, build what we believe to be the next peace leaders of Africa through this Africa Peace Fellows initiative. I'd be glad to talk to you some more about, and I'll leave some of the flyers here as well. I think that's it. Peace.
Thank you very much, Professor Ernest Uwazie. Professor Ernest Uwazie, we have a token of appreciation for you. I know you're going to be going back. You're not going to be here until the last day, until Thursday. You're going to be flying back to Sacramento. But we have a token of appreciation for you. If you could come forward, Professor Ernest. So because you're going to be going back, we're just going to give you the award that we normally give the keynote speakers. You will be the 5th person to receive this. We should give an appreciation to 2 people that we invite to our conference each year to speak. So in recognition of your outstanding contributions of major significance to alternative dispute resolution, I am honored on behalf of the ISERM family and everybody here to offer this award to you.
Thank you very much.